Respected Professor Dr. Moinathar Sir, Director, Institute of Legal Studies, Dr. Sudhir Avasthi Sir, Dean, Institute of Legal Studies, all the respected faculty members, collaborative batchmates, and supporting juniors. Nelson Mandela once said, to deny one's human right is to challenge one's humanity. Human rights is an urgent need of the hour which has to be realized by every section of the society. With this, I, Nishan Srivastav, student of BBA LLB Honours 5th year, would like to welcome all the learned intellectuals and inquisitive participants to this thought-provoking and one and only national webinar on impact of COVID-19 on human rights and rule of law. Firstly, I would like to give thanks to Mr. Aftab Muhammad sir, who has joined for today's session, and he is the keynote speaker of it. Thank you so much, sir. You accepted our invitation. So now I would also like to reveal one thing, that for this special session, we have received at least 400 plus registrations from across India, which I think is a huge achievement for all of us. And it is all because Aftab Muhammad sir. Thank you so much, sir. You joined for today's session. And now I would like to take this opportunity to introduce you all to Aftab Muhammad sir. Sir has completed his LLB and Masters in Social Work from University of Delhi. Sir has also been an alumni of our university, that is Institute of Legal Studies, Shri Ramswaroop Memorial University, as he has completed his LLM from here itself. Sir has supervised more than 15 research projects. Sir has also written many handbooks and research modules for prosecutors, officers, and judicial officers, uh, so that they can be, so that they know how to deal with respect to human rights and child rights. Sir has Sir has also designed a diploma program, which was a combined initiative by University of KwaZulu, South Africa, and UNICEF. Sir has also been a part of UN peacekeeping forces in Malaysia. So, without wasting a single moment, I would like to connect with Aftab Muhammad sir. Sir, over to you. Sir, I think you are not audible. Ashish, is sir audible?
Hello. No,
Am I?
no, sir, you are not. Yes, sir, you are not audible.
Yes,
Okay,
sir, you
thank
are
you.
now audible.
Now,
Okay, sir.
so
Okay, sir.
thank you. It's my pleasure to be in my own alma mater. I have done my LLM from here, and thankful to the director, Moin Sahab. He is also my teacher, and Avasti Sahab. He is also my teacher, and all dear students, those who are participating today in this discussions on human rights and rule of law during pandemic COVID-19. So, as I said, that when you speak to your own institute, in your own institute, it's a really immense matter of immense pleasure. So, without going further in introductions, I will come straight on the topic that how the COVID has changed our life, and we all know, and we live through it, and we are living through it uh, in last 6 7 months, and it has impacted each one of us in many different ways, not only in India, but this is the pandemic which is global in nature. Almost every country in the world is suffering, and that's why it's a pandemic. So how it has really impacted the whole human rights and the rule of law, and we will try to understand through this. I hope we will also get some opportunity to interact with the students, because that I come from as a practitioners, and it gives me a pleasure to not just for my own academic purpose here I am talking, but more from the practitioner's point of view. So particularly interacting with the young youth students who are going to be the lawyers, judicial officers in future. So it will be really grateful if we can interact towards the end of this session. So let me go into my lecture, and little bit I will get it switch off my camera so that I will. Can you see me now?
Yes, sir.
So I will
You
switch off my camera so that I can read some of the things because, and then again I will appear on the camera. Hope that will work for you. Okay, so that's where I am. So we all know most countries have declared a public health emergency to this pandemic or to the equivalent state of alarm. They have adopting extraordinary or exceptional measure to deal with the dangers and serious situation created by the COVID pandemic. For the first time in the contemporary world, we are facing a global state of emergency. This situation represents a challenge and in many cases a danger to democracy, the rule of law and human rights. These extraordinary measures that are adopted to fight the COVID pandemic should use, here I underline it, proportional means to achieve the legitimate purpose of guaranteeing the rights of right to health, physical integrity, and to life. These measures should not restrict rights unnecessarily or disproportionately, much less dismantle constitutional protection and restrict the rule of law and democracy. So this is the situations we are into. In that situations, what can be a proportional means to achieve legitimate purpose? And that I will bring your attention. You all are a student of law, and I'm not going in detail about what is human rights and what is rule of law. That I assume that the student of Ramswaroop University Institute of Legal Studies are very well aware. I know the quality of education you all and the teachers really working hard. So I'm not going in detail. I'm just giving you some snaps what the international laws says about it. Siracusa principle on the limitations and derogations provision in the International Covenants on Civil and Political Rights says, and here I quote, public health can be invoked as a reason to limit certain rights. So my friends, public health can be invoked as a reason to limit certain rights in order to allow the state, for what purpose? Allow the state to take measures dealing with a serious threat to the health of the population or individual members of the population. For this purpose, it allows the limit the certain rights. In such cases, measures should be specifically aimed at, and what should it purposely specifically aimed at? Preventing disease, A, or injury, or providing care to the sick and injured, as per the WHO standards. For that purpose, in Siracusa principle, there can be a reason to limit certain rights in the interest of the people, health, or individual members of the population's health. However, a public health emergency does not put the state institutional structure in danger, but the physical integrity and life of the people. Any health emergency don't put the state itself in the danger, but the people of the state. And that's why it's important that the stake of protection of the population, not that the whole limitation of the rights during the health emergency should be for the sake of the protection of the population, not the state itself. This is the very important point I'm going to touch upon, and my friends, I will request you to pay attention to this part. Max Planck Institute Research Series 2020-23, Carlos is a well-known researcher. In his paper mentioned that accordance with the institutional, constitutional and international standards, exceptions measure must be 4. And what are those measures? One, it should be necessary. Only right can be limited when it is first, necessary. Second, it should be gradual, not sudden.
Aftab sir,
Yes, yes.
Sir, sorry to interrupt you in between, sir. Can you please open the mic, sir? Open the camera. Sorry, sir.
Okay.
No issues.
Hmm.
Okay, sir.
Camera, then hi, I will see my lecture.
Yes, sir. They can
Hello.
see. Yes, sir. They can
I
see.
can see. Can you see
Yes.
my face now?
Yes, yes. I can see, sir.
Okay, okay. Good.
Okay. Thank you so much, sir.
Okay, great. So what are those uh, exceptional measures and the condition for that? One, it should be necessary, gradual, temporary, suitable, and very important, it should be proportional. Only on those four parameters that certain limitations to the right can be. Exceptional and extraordinary measures has been adopted by the state in response to COVID-19, also subject to international regulation and control. International human rights law fundamental provision that govern and control state exceptions, health emergency at the United Nations, and you may be aware, most of all of you will be aware about this International Covenant on Civil and Political Rights. And if you remember, Article 4 specifically talk about exceptions during health emergency or otherwise. And it says what Article 4 says, and I quote, in the time of public emergency which threatens the life of the nation and the existence of which officially proclaimed, state parties can adopt provisions that derogate from their obligations under the present covenant to the extent strict required by the exigencies in the situations, provided that measures are not inconsistent with their other obligations under the international law and do not involve discrimination solely on the ground of race, color, sex, language, religion, or social origin. Just to summarize these things, what does it mean? It means, in simple language, the International Covenant on Civil and Political Rights, Article 4, says that in times of public emergencies, which threatens the life, the nation existence, including the health emergency, a state can adopt provision that derogate from obligation under the present covenants. So international covenants provide that thing, but they say it should not be involved on the ground of race, color, sex, language, religion, or social. However, and that's very important and need really attention, that the International Covenant on Civil and Political Rights says does not authorize the suspension of human rights, the corresponding international obligation of state related to Article 6. What is Article 6 of the ICCPR? Right to life. Article 7, provision of torture. Article 8, paragraph 1 and 2, provision slavery and servitude. Article 18, provision of contractual imprisonment. 15, principle of legality and criminal non-retroactivity. 16, Article 16 of the Covenant, recognition of the legal personality. And Article 18, freedom of thought, conscience, and religion. So what it says that they can limit as per the Article 4 of the International Covenant of Civil and Political Rights that during an emergency a state party can adopt derogations, but that derogation should not really touch certain articles. And what are those articles? Important, related to right to life, tortures, slavery, right to religion, freedom of thought, consent. So these are the things. And suppose any state need to do, they have to declare the state of emergency and they need to convey the same things to the United Nations through the Secretary General that they have terminated these things, obligations. And whenever the situation get back, they have to further make them effective. In the same way, that was I was talking about the United Nations systems, international covenants of civil and political rights. As you know that there are this kind of human rights in the regional instruments also there. So inter-American level, the Convention on Human Rights, American Conventions in common parlance is called, in article, like in ICCPR Article 14, in American Conventions on Human Rights, in Article 27, they also say the same thing. Then in time of war or public danger or other emergency, they can do the derogations of certain measures, and almost the same what I call in the ICCPR. In the same way, you will find the other very important, the European Convention on the Protection of Human Rights and Fundamental Freedoms. In that Article 15, derogation in the time of emergency, they also talk that in time of war, in public emergency threatening the life of the nation, a state may take measures derogating from its obligation under the convention to the extent strictly required by the exigencies of the situation, provided that measures not inconsistent with other obligation under international law. So what we have seen? We have seen international law in United Nations conventions, then the Pan American Conventions on Human Rights, now the European Conventions on Human Rights and Freedom. They all have certain provisions that in emergency they can, uh, but with the limitations. They cannot really touch certain rights, and those I have already spoken in this. However, let's also move to the south. Africa Charter on Human Rights and People's Rights, unlike other international universal and regional instruments, does not contain an express clause on the suspension of the treaty obligations of the state parties in case of exceptional circumstances that endanger the life of the nation. So in international conventions on civil and political rights, we have seen under Article 4. In American Conventions on Human Rights, we have seen Article 27. In European Conventions, Article 15. But in African Charter on Human Rights and People, there is not any expressed clause like that for the suspension of the treaty obligations on the state parties. However, they can, because they are the part of the United Nations systems, they can evoke the same clause with under Article 14 of ICCP. So far we have talked, just make an argument that yes, when any nation's state parties facing any public health emergency or any internal emergencies, they can suspend the obligations of the international treaty, but provided they have said that they will not touch something which is very fundamental to rights. And some of the things which I have talked, there's a right to life, right to faith, right to conscience, right to other things, which is something very fundamental to our living. So this should never be touched. So that's the things under the international things. Now let's look at from that perspective. Now let's come back to our Indian context, our own context, that how this COVID is really affecting our day to day. So friends, you might have seen that once that the whole lockdown has been imposed, and then what happened? Suddenly you might have seen that the many people, those who were working in different cities for their livelihood, they lost because the factory was shut down, wherever they were working, shut down. They didn't have any means to earn livelihood, and in that situation it was very difficult for them to stay there. And that's why you may have seen that many people, migrant workers especially, have to come back to their native place. In UP alone, around 4 million people has come back. In Bihar or many other parts of India, people from Bombay, Mumbai, Delhi, or those big cities, those who are working migrant, they have to come back. So the questions arise. When they were coming back, many of them times they don't have the really means of travel. So many of you have seen that they were on trucks. Many of them really just walk through. And unfortunately, some of them have lost their life. When they were coming on that way, you might have seen many don't have even have a chappal or shoes. They don't have. Many of them have not the food. And on that, addition to that, many have really faced police lathi as well. Now the question arises, what's the human rights of so many people? And that the questions whether because this is a health emergency, that's why it's suspended, or there's still these poor people who have lost their livelihood have their rights. And we as a student of law, we have applied the legal mind and human rights framework to see how it happens. Other questions you might have seen in the newspaper also, that Uttar Pradesh government also and Gujarat government brought the notifications for the suspend that the workers in the under the Factory Act Section 5, laborers will be not entitled to the overtime work. And in that very recently, few days back, just I think that is very recent judgment, Honorable Supreme Court questions Gujarat government notification exempting factories from paying overtime wages to workers during lockdown. And that's the human rights protection. What the Honorable Court says, the bench noted that the statutory rights of worker cannot be set aside by the Gujarat government as the pandemic is not an internal emergency threatening the security of the country. The bench of Justice D.Y. Chanchor and Indu Malhotra, Justice Malhotra and K.M. Joseph ruled that the pandemic cannot be reason to junk statutory provisions that ensure dignity and the right to proper wages to workers. The court, while questioning the convener, said, and that's very important part here, I read from the judgment, the right to life guaranteed to every person under Article 21, which includes a worker, could be devoid of any equal opportunity at social and economic freedom, is the absence of just human condition of work. A worker's right to life cannot be deemed contingent on the mercy of their employer or the state. The notification in denying human working condition and overtime wages provided by law are not affront to workers' right to life and right against forced labor, and that are secured by right Article 21 and 23 of Constitution. So that's the very powerful court interventions in the petition filed by Gujarat Mazdoor Sabha and Trade Union Center of India. So that's how that the Supreme Court has come in to protect the rights of the laborers when the state government notified. As a student of law, you might have noticed also the same things the UP government has also notified. And in Uttar Pradesh Workers Front versus Union of India and others, the Allahabad High Court has also taken the notice. But good thing that happened that Uttar Pradesh government has withdrawn that notification. They said, no, that's not something, we are not going with it. On 8th month, they say that they have withdraw that notification. So that's the way we have to see that how the human rights of the laborers has been protected when it was challenged, protected by the High Court and the Honorable Supreme Court. Now let's move on the other rights, which is also see how these are threatening and challenged, not only in India, but all over the world. And some of those things, it's really the very major part because of the COVID, operate like any other industry, service, your own university or many other offices. The operation of the court also suffered. In general, the COVID pandemic has affected court operation of courts around the world. The International Commission of Jurists, ICJ, conducted a brief study of the special measures adopted in various countries during the COVID-19 pandemic, which affect the functioning of the courts in terms of due process and right to a fair trial. According to this study, in many cases, the court have generally suspended their activities, procedure, except in those matters that are considered urgent. And that is something it's really need our attention. Except those matters that are considered urgent. Underline this word. In turn, the process of the problem of defining which issues and measures are urgent and which are not in, in order to avoid arbitrary interpretations. So as I said, that court operation also, and in India also, or other high courts also have taken urgent matters. The interpretations of urgency and urgent matters, it's wide interpretations can be. What is urgent for one person, maybe not for others. And you, as a student of law, can debate, discuss within your class, among your friends on that particular aspects. So furthermore, it is important to emphasize once again that in time of emergency and extraordinary measures, an independent, impartial judiciary is needed more than ever to protect victims' rights and to control the actions of the government. And to control the action of governments. Otherwise, national constitutions, democracy, the rule of law, and human rights are also put in quarantine. They will be also say, okay, this is the time of COVID, so go in quarantine. That's why more than ever before, the court's vigilance is very important so that any violations of the human rights cannot be go unnoticed. But this has also given an opportunity in many countries. So in India, to find the new ways and means to ensure the functioning of court. First, online measures, and now in many cases, the hybrid measures. Some of the cases, maybe in other countries, now they started physical trial, and many places is still online. It's happening. So how to really, in India particularly, or many other underdeveloped economy, they don't have a IT infrastructure yet developed, particularly in the remote area. And in that situations, to running a court online could be a major problem. So this could be also a learning how in such situations, if may arise, how the state will be prepared, and particularly the judicial apparatus, our justice apparatus will be prepared to deal with other situations. And there is a need to upgrade the infrastructure, particularly IT infrastructure in this situation. So one is that, and because of that, you might have seen there is also relaxations in limitation acts or many other things our judiciary has done in India and many other countries as well. Other things, and I will talk it more broadly, not Indian context only, but globally also, that because of this whole pandemic, the need for social distancing or physical distancing, there was also suspension of public meetings and protest. Because if there is a crowd and people are in, it will spread faster. So it was needed. But this suspension of public meetings and protest should qualify the four things which I talk about. And what are those four things? Once again, I repeat it. It should be necessary, gradual, temporary. It should not be on the excuse that, okay, so it should go long and long. When the situations really ease out, it should be not its suspension should be revoked, suitable and proportional. So in many countries, many government has really suspended, taken the advantage of the COVID and suspended the public meetings and protest. However, now, because of the online situations, social media, now protest can not only through on the street, but through online platforms also. So at least people are in whatever ways, and you might have seen in America, Black Lives Matters, people has come on the street as well as online. They have a fight for the rights of the black people. Other things is operation of parliaments, and so in COVID, if suppose a country in high cases, how they will run the parliament? And if parliament is not running, who will check and make the government accountable? Because as we know, legislature, it's very important. Legislatively most needed so that they can exercise their essential functions. Legislative control on the executive, it's very important for any functioning democracy. So how in many countries for last 6-7 months they are not really trying to push or postpone this parliamentary procedures. Many of the countries cutting down the many of the procedures. In our own country, you may have seen, and you can debate among yourself whether the questions hours should have been shortened or it should not be allowed, or what should be on that, or it should be like as usual the whole full-fledged discussions in the parliament. So this pandemic has really thrown the challenges, and our system need to find the ways and means that how in these difficult situations parliamentary proceedings in different ways, whether it's electronically, online, or otherwise, these need to go on so that legislative questionings, control on the executives, and make them accountable can happen. Because in any functional democracy, it's very important parliament has a big role. Now let's come on to the few other rights, human rights, how they are getting affected during, and what will be the ways and means to address those. Right to education. Right to education, we all know now it is a fundamental rights in our constitutions. There is also a special law on right to education law act we have. But because of the COVID situations, particular schools are closed almost for last 6 months. Children cannot go to school. An executive has taken right decision because of they don't really want that this should spread to so stop the spread. They have taken that decision in the welfare of students and children. But how about the learning loss? The children are facing almost 6 months no school. So question is coming whether their human rights are violated during this time, right to education violated. One may argue that, okay, now online educations are there, but we also have to take account of the digital divide in our country. How many children and their families have a smartphone or they have their own personal computer with internet access? Even in the middle class, if there is a one laptop or computer or one smartphone, it is for a family. But in the family, there are 3 or 4 kids of the school-going children. Who will access those? And as you know, in our society, if you have one laptop in your family and you have 2 sons, 1 daughter, most likely the laptop will go or the computer will go to the son. So that's here another layer of the discrimination you will find within the family. If the resources is scarce, they will prioritize son over daughter. So whole loss of education, that's another fundamental right. So how the state can ensure that children education, learning loss should be prevented? What the strategy they have to come if they know that the situation is going to be like this for a long time? What other alternative solutions can be? That need to be, because as we know, particularly 6 to 14 years old children, it's a fundamental right to education. But they are missing out now their education, except those who can afford online education in private schools. And in government schools, on the TV and other, we know the quality of learnings and access. That's the big question. Let's move on to the other points. Access to health. And here I give you one story. One person who was working in Punjab National Bank, who was tested positive in Eastern UP. So firstly, he was home quarantine, and later when he feeling not well, so he approached one private hospital that he wanted to get admit. So his relative went to a private hospital. The private hospital told that the first I want to have a video call with the patient. They say, for what? The private hospital administrator told that first I want to ensure that this person is in good shape. If he is a bedridden, he has a higher complications, we are not going to intake. Then the relative argued, that's the look, if he is all fine, why he will get immediate admitted? We are want to get him admitted in the hospital in the very first place because he is not well. That's the reason. So you can understand that a middle class educated person who is working in a Punjab National Bank as the responsible position, perhaps as the regional manager or something like that, he has to gone through so much. What will happen to those who don't have any means? So right to life, right to medical services, irrespective of human rights, any their income status or their caste or their religion or their sex, their ethnicity. So that's the another big challenge, how to really address those things. Now other nuances, because these are the some things we need to discuss about those things in our discussions. If you remember during the lockdown especially, it was so much focus on the social distancing, that at least there should be 2 feet distance between one person. Can you think of the in Lucknow or anywhere in the slums area, the person has only one small juggi in which 5 or 6 people staying there. How they will manage the 1 feet, 2 feet social distancing norms? That's the questions need to be asked. Especially for those workers, daily wage workers, those livelihood, they're only able to eat when they go to work every day because they don't have any means. So suppose now there is no work, there was no work during the lockdown, especially in those days, how to survive? It's a good that many state governments in India have come up and started providing ration so that at least people can survive, able to eat some. So the larger question is through that if something like that happens, how the right to live, right to food, it's something very important. So a state need to make the provisions to ensure that all the citizens in the state really receive adequate food assistance during those times. Now I will move to the couple of other rights which usually are challenged during the COVID, and I'm not only in India but across the globe. And one of those is right to information. It is very important that people should know, have a right to know what is all about COVID, what the situations, how the government is taking measures, what need to be done in very transparent manner so that people can make their choice based on the information. But unfortunately, we know that during the lockdown and COVID pandemic, across the globe, many countries has really used this opportunity to block the informations to the people. Reduction in the public's right to know about the activities of their government counterproductive to the efforts of combating COVID-19 outbreak. The right to information is crucial for ensuring public awareness and trust, fighting misinformation, ensure accountability, as well as developing and monitoring implementation of public policies aimed at solving the crisis. It is crucial that the right to information is maintained during the emergency as much as possible. But what happened in Spain, Italy, or many other countries, they curtailed down the information. People were not aware that how many cases really it is, how they are counting the cases, what are the tests they are conducting, which method of the test they are employing. So it's very important right to information during this time. On the contrary, a state says that because it is an emergency, they will not able to provide that information. Where on the contrary, the state should make efforts to make this available because it will help the state to fight the misinformations, ensure accountability, and people's participation in this fight. So that's the another area, the right to information and human rights aspects. Now let's look at on the right to privacy. I give you one example here. In right to privacy, in the beginning of when this pandemic, in April or something, the person who went to the hospital tested positive. On the door, they have put the authority has put the COVID positive, and he was and his family completely isolated in the society, stigmatized. No milk person was going to deliver milk. Every essential commodities they are deprived of. So it is very important to right to privacy, particularly during this time. And as we know, the Supreme Court has delivered in a landmark judgment holding the privacy as a fundamental rights under the Indian Constitution. So it is a look. I will give you some view how it is happening at international level. The whole new technology, data, tracking, surveillance, medical surveillance through app, how it is happening and what will be its impact. In order to limit the spread of the coronavirus, experts emphasize the importance of tracking of every contacted infected patients have with the others. Countries such as China, Singapore, South Korea, and Taiwan have all taken aggressive measure trace all potential contact infected people have they had. These measures are widely considered to be a large reason why these countries has been successful in lowering the rate of the transmission. People attribute that maybe because of the whole tracing. However, the aggressive measures taken have come the cost of the individual privacy. Taiwan and Singapore, for example, regularly post detailed information about everyone who tests positive, including where they live and work, what train station they have used, what bars, restaurants they have frequented. South Korea now has an app that allows users to track exactly the movement of those infected. Countries are also using location data to enforce quarantine for those infected. Israel, for example, is now using data collection technique previously used to counter terrorism to effort to identify anywhere potentially exposed to the virus. The government uses this information to send text message to those exposed, ordering them to the quarantine. So look, it looks so nice that through app you can track who are going, but at the same time it's scary, isn't? That how you will feel that suppose your director will put a chips on your shoulder and will track every minute where you go, whom to you talk, how many hours you study, how many class you have bunked, what you said about the teacher, everything the director Sahab is noticing, how you will feel about it. So here also, as I said that, okay, certain measures is required, but the fourth principle which I have talked about, it should be gradual, it should be temporary, it should be proportional. All those things should be, or it should must be essential only as much as required that required. It should not become the norm for the state as a police state to really track every single individual. And then it will make, thanks God, our Supreme Court, Honorable Supreme Court has said that it is a fundamental rights. Now let's move on to the couple of very quick points. I think that already taking almost 1 hour. Respect dignity after death, the last rights as per their culture, traditions, religion. In COVID, you may have seen that, and also this is also a right to life, right to this last rights is also a right to life of the deceased person. So in COVID times, in many countries, it happened that people were not really aware what happened to their relatives, to their father, to their son, to their wife, sister or brother. Because in many countries, they're not really aware that protocol laws very clear. And this is the big challenge it happens during time. In India also, in March, April, May, it was a big struggle. Now slowly we get better on that. So that's the another challenge there. But as I said that our court has played some good role in that to monitor as a guardian the constitutions. And as my teacher, what I have also learned in the very institute, Institute of Legal Studies, Ramswaroop University, that any lecture on law cannot be complete without quoting certain cases. So here very quickly, I would like to quote few cases and then I will end my. So for human rights things, in human condition at quarantine center and for providing better treatment to corona positive PIL, Allahabad High Court Chief Justice Govind Mathur and Justice Siddharth Verma taken cognizant and has given directions to the state. So that was something which has been. Then another one is in Patna High Court has taken suo motu writ petitions If you remember, there was a one girl was playing with the mother who was died in Muzaffarpur railway stations. They have taken this. Taken other things which I have already talked about, the laborers notification which were denied to the laborers. In the same way, in Andhra Pradesh also, that High Court has taken cognizance of the people, migrant people were not allowed to go to their home. So court has intervened in that and asked and given the direction to the state government to provide the all facilities and the food and ration to the victim. So in that way, there are many cases where the court has actively intervened, particularly the high courts of various high courts have intervened in the situation to ensure and uphold the human rights of the people during pandemic also. Other very recently also related to the court order interest on the interest during moratorium, you may be aware that the government has identified, government has said that they will moratorium on the loan for 3 months, and then they said that okay, they will extend further. Very recently in the affidavit, just 2 days or 3 days back, I guess, in an affidavit to the Supreme Court, the government has said due to unprecedented condition, the only solution, and I quote, the only solution for the government to bear the burden of waiving of the interest, and that will seek the parliament approval for the decision taken. The move all benefit thousands of the borrowers. So that's the another interventions you can see, because those who have already taken the loan will have a moratorium, and they will pay again interest on that. It will be a heavy burden on that. So in that's good that finally the Supreme Court, government, central government has given affidavit that they are considering to waive off the interest. So these are the some of the things the court has taken cognizance during. As I said, that we are living in a very unprecedented time. We never thought that we will live in a time where we cannot really able to hug our own family members. We're not able to see them. Even somebody have died, and if you know somebody has died of COVID, we're not able to go in the last rites of. So this is really, really unprecedented time. And in that time, like many other things, human rights are also on stake. But the questions is, and particularly those who are working and defenders of the human rights, to keep about these things, talk about things, have a discourse, and you as a students have a discussion, debate your own this kind of online discussions, many more discussing among yourselves, or you can have a debate topics, whether during COVID that can parliament certain features can be reduced, discussions can be reduced. That could be one topic for the debate. Can certain topics will be the right to labor suspension during the time of COVID, right to treatment of the COVID during the COVID, because you may know that there are many people who have the pre-existing conditions and they want treatment because now the hospital is full with the COVID patient, that the general people are not really able to get the treatment. They have to keep postponed, and it's harming a life. Sometimes it's life threatening. So these are the topics you can have a discussions, debate, discourse, applying the framework of human rights and principle of rule of law. It will further enrich the whole discourse. On these points, I would like to end my presentations with John F. Kennedy, who once said, "Right of every man are diminished when the right of one man is threatened." And I always, whenever I read these quotations, I make some changes, because John F. Kennedy only said the right of man, and I say human being, because women we cannot. So right of every human being are diminished when the right of one human are threatened. It's very important for us as the human rights defenders to use inclusive language, in our discussions. That's why instead of mankind, we should use human. Instead of chairperson, we should use chairman, you should use chairperson. Like that. So we should use more inclusive human rights awards. Thank you once again. Thank you, everyone. Thanks a lot.
Hello, Ashish, am I audible?
Yes, Nishant, you're audible. Hello.
Hello,
Yeah, Nishant, you're audible.
sir. Am I audible to you?
Yes, yes, very much, Nishant.
Okay, 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 sir. Thank you so much, sir. This session was really means enriching for all of us, and thank you so much for sharing your wisdom with us. Now, sir, there are a list of queries which I think you which has to be sorted out by you. So, shall we begin,
Absolutely,
sir?
that's good. Yes, yes, yes. Whether I
Okay,
was
sir.
audible to all of you,
So, sir, the yes, yes,
Nishant,
you were
whether
audible,
I
sir.
was audible to all of you.
Yes, sir, you were audible.
Okay, great. Go ahead.
Okay, sir. Sir, the first query is from Ashish Pathak itself. Sir, he wants to ask that recently many governments are issuing the notification that those who are above 50 years of age, they will be given VRS. So don't you think that this has been a violation of human rights amid lockdown, means after lockdown?
Yeah, these are the
Because
also.
sir, they would
That's
be
why.
retiring at
Yeah, that's why the we have to see whether it has been three, four things need to be looked into. Why they are asking the government notice? It will be for everyone, just all those who are 15 years old. So now the retirement is going to be 15 years. Is or it are saying that those who have a fragile health, they're not able to do, they will have to take the or they it maybe are meeting the criteria that it is based on the performance. So we have to see that what are the policy framework the government is coming up, and based on that, it need to be reviewed, examined, and then in that view it can be looked into. And if feel that okay, that is something it can be challenged.
so, so sir, by this notification, can we interpret that the prime minister and the key post ministers should also be below 50 years of age? Can we interpret this also?
Nishant,
Because
I say that
because
before,
they
yeah, before making any conclusion, it will be really good to read the notification, what the notification says, and only
okay,
then make an opinion. And that's why I will urge Ashish, who has asked the questions, or any other friends here, that first you examine. And as a student of law, we
oh,
are always trained in that first the examining that what are the legal questions arises out of the notifications, look at what are the rights are violated, which are the laws are violated, and then make an opinion based on that. So I have not gone through the notification, so it will be very difficult for me to say anything on that. But because I am talking with the student community, in a principle, I will suggest always good to first critically examine the and then make an opinion based on that.
sure, sir. So, sir, there is another query. Sir, if we take the human right aspect, if we take it in a global aspect, sir, you must have heard about the George Floyd case in America, who was racially discriminated by the police officers, and he has been we can say that he has been killed by the police officers. He was shouting that, "Yeah, I can't breathe," because they have put their knees on his neck. So, sir, despite of having such rules like Universal Declaration of Human Rights and International Covenants of Human Rights, don't you think this has been a violation?
Absolutely, it was violations, and that's why the whole world was against it. They protested it, and the person has been arrested, and now the law is taking its own course. It is the violations, and that's why this I also take opportunity because you told me that around 400 students have joined these things. It's very important we
Yes.
all have no matter what will be our area of expertise, whether we want to be in corporate law, business law, intellectual property, or criminal law, or whatever the area of our expertise going to be. But as a lawyer, basically, we all have to be well versed and aware about the human rights, because essentially, law is to protecting for the those who are marginalized. That essentially, I feel that's the role of the lawyers.
Thank you, sir. Sir, just one last query, sir. You might have heard about the Hathras rape case, sir. If we take that case into consideration, there has been violation of two major rights: Article 19 and Article 21. Article 19 says that freedom of speech and expression, and Article 21 says that right to life and personal liberty, which also includes right to die with dignity. And the Hathras means the administration has burned the dead body without taking the consideration of the family members, and they were also not allowing anyone to go near the victim's house. So, what's your opinion on this, sir?
No, definitely that's the rule of law, and the human rights principles should be and must be upheld. And wherever any digressions has happened, the state must really address those issues, and if that required, that the court will look into that. You may be aware that the already Honorable High Court, Allahabad High Court, has already issued a notice in this regard, and they have asked the respective
Yes.
officers to be present in that way.
Okay. Thank you so much, sir, for sorting our queries. And now I would like to connect with our convener, that is Professor Dr. Moinathar, sir, to give the vote of thanks.
Thank you, Mr. Aftab. Thank you very much
Definitely,
for
lovely to see
for
you here. It's my pleasure. I told perhaps you were there or not in the beginning that it's such a
no, no.
pleasure to be
I'm
speaking to my
uh,
teacher. So it
I'm
was
here
really
since
pleasure.
beginning,
Hmm.
but a lot of network issues because of that. Regularly, I'm delinking and joining, delinking and joining. But I have witnessed your presentation. It was lovely, and it may be informative for the students. I'm highly thankful to you that you have given us your precious time, and I wish that from Mr. Aftab you will become Dr. Aftab with the efforts of Dr. Ramswaroop, Ramswaroop Memorial
No,
University,
that's my
and
dream. That
my learned colleagues.
I wish to be a student of yours. There, so hope so. Yes.
Uh, Definitely. May God do so in near future. I'm really thankful to you. I'm also thankful to my learned colleagues who are here to join this webinar. I'm also thankful to all the students who have attended this webinar from various different places. Although this webinar was very much informative as far as the COVID situation which is going on, pandemic situation is going on at present, and many more issues regarding humanitarian issues you have covered, and really it will be beneficial for the students. I hope that the student must have been benefited from your presentation. I'm highly thankful to you, my learned colleagues, and all the higher authorities of my institution, Chancellor sir, Pro Chancellor ma'am, VC sir, Pro VC sir, Registrar sir, and all the deans and directors, and my learned colleagues and the students for whom this webinar should be very much informative. Thank you very much, Dr. Aftab.
Thank you, sir. Thank you. Thanks a lot.